The criminal charge, once known as improper telephone communications and now unlawful communications in Louisiana, is a misdemeanor offense. Unless you have prior convictions for the same charge, then it would be a felony. Either way, you must take this charge seriously, as it can leave a blemish on your criminal record that could negatively impact your future. So what is unlawful communications in Louisiana? The statute states that no person shall engage in or institute a telephone call, telephone conversation, or telephone conference with another person, or use any telecommunications device to send any text message or other message to another person directly, anonymously, or otherwise, and therein use obscene, profane, vulgar, lewd, or lascivious language, or make any suggestion or proposal of an obscene nature, or threaten any illegal or immoral act with the intent to coerce, intimidate, or harass any person. So what does this mean? The provision of the statute basically prohibits anyone from calling or texting anyone else and using bad language. You also can't make an obscene proposal such as asking for sex. Finally, the statute makes clear that you cannot threaten any illegal or immoral act with the intent to threaten or coerce another person. Therefore, it's illegal to contact another person through phone or text and threaten to beat them up. The statute also states that no person shall make repeated telephone communications or send repeated text messages or other messages using any telecommunications device directly to a person anonymously or otherwise in a manner reasonably expected to abuse, torment, harass, embarrass, or offend another, whether or not the conversation ensues. Now, I find this to be the most common provision that defendants get charged with. Basically, this provision makes it illegal to repeatedly call or text someone in a way that would harass another person. The statute even states that the message is not required to be repeated, just another message that could harass an individual. The statute also ends with whether or not conversation ensues. Therefore, if the recipient is responding, it is not a defense. The prosecutor must prove that the defendant to improper telephone communications was making the unlawful communication in the first place. The statute states that no person shall make a telephone call and intentionally fail to hang up or disengage the connection. This provision is straightforward. It prohibits anyone from essentially crank calling another person, which means to call and to not say anything. The statute states that no person shall engage in a telephone call, conference, or recorded communication by using obscene language or making a graphic description of a sexual act or any telecommunications device to send any text message or other message containing obscene language or any obscene content anonymously or otherwise directly to another person when the offender knows or reasonably should know that such obscene or graphic language is directed to or will be heard by a minor. Lack of knowledge of age shall not constitute a defense. What does this mean? This provision to unlawful communications was created to protect minors from being exposed to obscene language or graphics. The offender can be charged under this provision of unlawful communication in Louisiana if it is reasonable that the message he or she sends could be viewed by a minor. The offender cannot claim that he or she did not know of the minor's age. So be careful what you send in a text. The statute states that no person shall knowingly permit any telephone or other communications device under his control to be used for any purpose prohibited by this section. Now, what does this mean? This provision of the statute is designed to give prosecutors the ability to charge individuals with unlawful communications if they didn't make the communication but knew someone else was using their phone, their computer, their tablet to make unlawful communications. So you may be charged even if you weren't the one sending the text, as long as it can be proven that you knew someone was sending unlawful communications with your phone or device. This provision basically eliminates the defense of oh, someone else used my phone to send that. If that defense is used, you must be prepared to call that someone to trial so they can be questioned. Where is the defendant charged? Any offense as set forth in this section shall be deemed to have been committed at either the place where the communication originated or at the place where the communication was received. Now, this is the jurisdiction provision, meaning that it defines what court the charge can be brought. For example, if the offender sending the text is located in Baton Rouge at the time of the text, but the recipient is located in Covington, Louisiana, then the charges can be brought in either Baton Rouge or Covington. What are the penalties for unlawful communications? Whoever violates the provisions of this section shall be fined not more than $500 or imprisoned for not more than 6 months or both. This is a misdemeanor. Now, upon second or subsequent offenses, the offender shall be fined not more than $5,000 or imprisoned with or without hard labor for not more than 2 years or both. And this is a felony. So what is a telecommunications device? For the purposes of this section, telecommunications device shall mean any type of instrument, device, or machine that is capable of transmitting or receiving telephonic, electronic, radio, text, or data communications, including but not limited to a cellular telephone, a text messaging device, a personal digital assistant, a computer, or any other wireless device that is designed to engage in a call or communicative text or data. I hope this video helps you understand the charge of unlawful communications in Louisiana. If you need a criminal defense attorney for this charge, give me a call. I'll be happy to help.